introductory presentation of EURAXESS and the European IP Helpdesk. For that, I would kindly request the help of Dr. Jenny Elmako. Thank you for the cooperation, so to say. I'm very happy to be with you here today, also sharing my video. It's very nice to meet you. In order to start with the webinar, I would say perhaps you can share your screen and you can start with the presentation of the EURAXESS activities, which, there we go. And I will mute myself to let you do this first introductory part. Thank you very much.
Thank you so much. And can you hear me well?
Yes, very well.
Perfect. All right. Thank you so much. Really, we're very happy that the EU IP Helpdesk is doing this very important training for us. Before you go to your main training, please allow me some slides to introduce to you or reintroduce to you EURAXESS ASEAN. So EURAXESS ASEAN is a European Research Action Service, and there are two of us actually, and you get to know a little bit about us in the following slides. But I just wanted to let you know about the platform that we have. So essentially, EURAXESS supports mobile researchers, such as those attending this webinar. And I see people still trickling in. So I hope that you get, I'm sure you will get a lot from this webinar, but I hope you also visit our website and our social media platforms so that we can continue to inform you about opportunities in the European research area. So in EURAXESS ASEAN, so if you Google, Google is everybody's friend. If you Google EURAXESS ASEAN, you can see a job and funding portal. Every day we have a listing of thousands of research fellowships and funding offers in Europe. So if you can just put like a search function, if you are in political science, bioeconomy, or tech, or whatever, and you depending on level of researcher you are, so you could be like an early researcher or a senior researcher, or if you are representing institutions, then there's a lot of job and funding available there. So just take the time to look at that. Also, we have the partnering tool where you are able to find a research partner. So you can search for individuals, research organizations, and businesses, and they can become part of your network. So it's a really great tool to find your partner in Europe and vice versa. So also check that out. There's also a hosting database. Right now, there are several calls that are open. And if you are looking for a host, especially if you are an individual researcher, and for example, you want to do your research in Germany, and especially in the sciences, let's say, so you can go to this part of the site and you can just put the keywords, whether it's a country or the particular research program, and it will populate itself, and then you can see a lot of things there. We also provide comprehensive information for mobile researchers on living and working in Europe. So if you're about to go to Europe and you have questions on visas or questions on lodging or on taxes, there's a wealth of information also on the EURAXESS worldwide website. And it's not just us here in ASEAN. There are currently 600 EURAXESS service centers in 36 European countries. Also in other countries around the world. We offer personalized, free of charge assistance for mobile researchers. And there's also a network of national experts to facilitate research collaboration. So we're really here to encourage you to have sustainable careers in research, and most especially in the European research area. So if you have any questions, do contact us for these. There's also a chapter in ASEAN for Marie Curie Fellows. If you are a Marie Curie Fellow or if you know of one, please tell them to get in touch with us. We have a very active Marie Curie Alumni Association chapter in Southeast Asia. So please join us for that. And yeah, I just wanted to flag this really interesting individual fellowship info session on the 20th of April, we have like incredible fellows. So if you want to get to know about the Marie Curie fellowships, especially for postdoc, there's a schedule on the 20th. There's also one on the 21st, and also another one on the 22nd. So if we will, on our social media sites, you can find that out. So we encourage you to listen to the policy officer, so to get to know about how to apply for these, and also get to know about the stories and journeys of Marie Curie Fellows. And this is us here in ASEAN. It's Dr. Susan Renzo Vasu. She is based in Singapore, and I'm Jenny Elmaco. I am based in Vietnam, but currently because of the lockdown, I am still in another place. So, but that's us, and please, we are at your service. Also, we have a EURAXESS chat. We have a podcast. It is available on Apple and Spotify, and we are going to make it available also in other places where you do your broadcast. But for now, we are on Spotify and Apple. So if you are stuck in traffic, or you're biking, or you're cooking or something else, and just search for us, EURAXESS ASEAN, on these two platforms, and listen to tips and tricks on how to get a doctorate or a postdoctorate, or how a hosting institution in Europe, and some other very interesting things there as well. So tune in to us too. And yeah, if you look at your get your phones and scan these QR codes, you can have more information about us. So with that, thank you so much again to our colleagues at the EU IP Helpdesk, and have a wonderful session. Thank you.
Thank you. Thank you very much, Jenny, for the introduction. I'll also go on with mine. I will not share my screen because of potential problems in the internet connection. However, you should now be able to see my screen, right? Let me see. Yes, very good. So thanks once again. I will take another couple of minutes in order to introduce the European IP Helpdesk and give you a couple of information about ourselves as well. The European IP Helpdesk is a service initiative of the European Commission that has the objective of facilitating small and medium enterprises and researchers, mostly, to understand and use intellectual property and intellectual property rights. In the field of research, we are very active in the support in IPR issues within EU-funded project, and now, of course, Horizon 2020 in the past, and now Horizon Europe. By IPR and IP issues, we mean proposal writing mostly, but also how to find potential agreement within the consortium, in the consortium agreement, and how to avoid potential issues that might arise throughout the project duration within the consortium. For MSCA fellows, we also have a dedicated webinar, which is actually, if I'm not wrong, going to take place next week, but we're going to see that in the next upcoming slides. And we have a, so to say, target groups, which is researchers and beneficiaries of EU-funded research, especially in Horizon 2020, of course, in the last year, but also SMEs and intermediaries providing innovation support. However, the services are actually open to everyone who is wondering how to use or take advantage of the intellectual property they have, or intellectual property rights they have generated. So those are the main categories to whom we provide services, but actually the services are open to anyone. And what are the services? Well, they are the ones that you can see here in the small clouds. The website is the center, the cornerstone of the services, by which you can have access to all the other clouds that you can see here in this slide. We had a old helpdesk website, which was www.iprhelpdesk.eu. If you type that, you're going to be redirected to another website, which is the new one hosted by the European Commission. It might be the case that you're not redirected and that you experience error 403. The Commission is actually working to solve that problem, but if that's the case, you can simply use Internet Explorer and it should be working. In fact, we have been gathered, so to say, as a family, European, China, Latin America, Southeast Asia, and India helpdesk into a new website that you can see here, ec.europa.eu/IP-helpdesk. That's the new comprehensive website that is complete of all the helpdesk financed by the European Commission. And most interesting, I think, for today's session, there is one dedicated for Southeast Asia, the SEA IPR SME helpdesk. I talked to you about a little bit of the services that we offer. There is a website, as I said, to which you can have access to trainings which are on-site and online, but also to publications, guides that we regularly publish on our website, and to audiovisual content, which is a channel dedicated on YouTube. And also social media are part of our action, like Twitter or LinkedIn. So if you happen to see us in Twitter and LinkedIn, you're actually very welcome to contact us. There's a helpline, as I told you, that is a very important service that we offer because it's a first-line support, which is personal and to the point. That means that the helpline is there to answer to your question regarding intellectual property and intellectual property rights within 3 working days. They might be contacted through email, phone, or through the website that I mentioned to you before, and the questions might be in following languages that you can see here. However, I would really suggest to write in English if possible, because every expert that we have available can speak English. Some other might not be able, for example, to speak Italian or Polish. Important is that all the questions that you undergo to the helpline are confidential, meaning that no sensible information that might be personal data or even description of the invention or information that you're going to provide is going to be shared with third parties at any time. We have trainings, they are online and on site. Of course, post-pandemic, we hope that the on-site trainings are going to start once again. For the last 1.5 years, we have been stuck and have not been able, so to say, to meet our users in person, but in exchange for that, we have a better online services extended that offered more thematics that you can see in the next few slides. We therefore have a couple of webinars more, and this is the list until the 7th of July. And you can see on the 21st of April, so next week, there is going to be a dedicated webinar on intellectual property and the focus for Marie Skłodowska reactions, and where we're going to talk about the peculiarities of the intellectual property issues within a MSCA action, which is something pretty peculiar and particular because it brings together academics and industry, and therefore for intellectual property it is a very interesting but also difficult field. If you are interested in any of those webinars that you can see here, or If you're interested to see one of the recordings of these webinars that have already been carried out in 2020, please do not hesitate to contact us, and we would send you a recording of the webinar. We also have ambassadors all around Europe. Those ambassadors are active in different countries and are there to translate and in general overcome language barriers that might be there between the experts, the help desk, and the companies or the researchers. So if you check out on the website, you can see where our ambassadors are in your country, and perhaps if you want to get in touch with them as well. They are professionals in the intellectual property field, and they are part of the Enterprise Europe network. So they are very qualified to counsel and suggest you. Those are a couple of contacts that I wanted to leave you in the slides, and after that the service presentation, so to say, is over, and we're going to start with the actual content of today's webinar. But before I start, I see Fahima has a questions that says, do you also have help in proposal writing applying for PhD to an individual? No, we do not do that sort of assistance, mainly because our assistance is based and limited to intellectual property issues. For example, if somebody is writing a Horizon 2020 proposal and has a intellectual property issues, we wouldn't really write down the proposal for them, but we would help clarifying the doubt or questions that they might have on the intellectual property or intellectual property right issue. That is something, however, important to remark, so thank you for the question, Fahima, because sometimes the services that we offer are a little bit misunderstood, and the questions that fall in the help that the helpline receives might then be out of scope. Now, having answered this first question, I would, however, also remind you that although you're muted, you're actually very welcome to ask questions at any time of the presentation. I will answer to your questions, and I will see them in the question and answer part of my screen. And if I think, like in this case, that it's important to answer immediately, I will do that. Otherwise, we're going to leave a question and answer session that is going to take place in around 1 hour after the content presentation is going to be over. So what are we going to talk about today? Well, today speech in the next 50 minutes or so are going to be about the peculiar rules of intellectual property in Horizon 2020 or in EU-funded projects. And we're going to cover the general rules and agreement that are part of all Horizon 2020 founded project or European founded project, and we're going to cover the specific vocabulary also that a beneficiary or a applicant should be aware of. And then we're going to mention a couple of information regarding the hints and tips in order to efficiently manage intellectual property in a project life cycle. That is a slide that, an introductory slide that explains why it is important to consider intellectual property in Horizon 2020. It might be divided, so to say, in two phases, the proposal phase and the implementation phase. And in both these phases, the intellectual property issues are very important to be taken into consideration. because exploitation issues are subject to evaluation, and that is something that you need to take into consideration when you write the impact part of the proposal. And many points actually are lost exactly in that part, because not enough attention is put on intellectual property and intellectual property rights. And also the rules for participation. So here we go on and we go to the life cycle phase of the project. The Commission is telling us that parties have to make their best efforts, commitment, in order to exploit the results. And very often these best effort commitments and the exploitation of the results is a central part of the proposal and the project, which is also strictly connected to intellectual property and intellectual property rights planification. Then a convincing and outline of IP management and exploitation strategy at a individual and consortium level within the proposal is very relevant. Is very relevant in the preparation of the project itself and while we are carrying out the project activities. Therefore, in many cases, to exploit, to be able to use the results, excuse me, of the research, it is necessary to plan about intellectual property, to see what kind of results might be protected and might not, and try to foresee that sometimes while the project proposal is being written. And finally, if we can plan and properly manage the intellectual property throughout the project and establish clear rules within the consortium agreement, all other agreements of the project from the very beginning, we have a sort of insurance to avoid future conflicts among the consortium. So if we set down the rules for joint ownership from the very beginning, or we agree that those rules are going to be then settled once the project, the results are going to be generated, there might be less chances for conflicts and within the consortium among the parties. But now let's start from the very basics, and the rules and the agreements that you either have already seen if you have taken part to Horizon 2020 project in the past, or that you're going to see if you're taking part to Horizon Europe project in the future. Well, the first step, well, this is a general overview of the situation with the founder, which is European Commission, that signs a grant agreement with the coordinator, to which other beneficiaries access. So they have an accession form to the grant agreement, and the coordinator, together with the beneficiaries, signs a consortium agreement, which is the base for the existence of the consortium that is going to carry out the consortium, the project activities. And the grant agreement, excuse me, the grant agreement is the first document that, well, actually it's in the proposal phase is the objective, because it's after the grant agreement is signed, then the funding from the European Commission might be received and the project is going to start. But during the project duration, the project life cycle, it is actually, so to say, the constitution of the project itself. All the most important rules are written within the grant agreement, and they might not be contradicted by any other contract or document within the consortium or the life cycle of the project. Those rules are financing rules, are organizational rules as well, but also intellectual property and ownership rules. And that is very important, because while those rules are in a way very general and leave space for interpretation, they set a standard of behavior that cannot be then contradicted within other agreements by the parties, for example, the consortium agreement later on. The consortium agreement instead is the document that is signed among the parties of the consortium, so the coordinator and all other parties. And this document is more useful in order to organize the internal life of the consortium, meaning when the parties are going to meet for project reviews and meetings, or when are the different bodies of the consortium going to meet, or how are they going to take decision, the General Assembly and the steering committee if it's present, and so on and so forth. But also here we have a section that are dedicated to intellectual property and intellectual property rights and their ownership and the access rights to the results. And all these rules that we can write down in the consortium agreement have to be added to the ones that are already written down in the grant agreement. The rules in case of Horizon 2020, in case of Horizon Europe, we still have to have a couple of information more, can be found in the rules for participation, in the model grant agreement, in the applicable work program, and also in the online manual that is still available. This is a link in which you can find some information more if you want to look for them a little bit by yourself. Now, you might have already heard that when I was describing the consortium agreement, or when I was describing the grant agreement, I have mentioned a couple of terminology that is very interesting under a proposer's point of view. And they are the following: background, results, exploitation, dissemination, access rights, and so on. All these words are to be understood in the meaning of the European Commission, especially if we are writing down a proposal. In fact, just to give you an example, in normal, or let's say in English, like real English, dissemination and communication are to be considered more or less a synonym. However, as we're going to see in the next few slides, under the Commission point of view and within, therefore, the Horizon 2020 and the Horizon Europe environment, that is actually not so. And for a proposer, it is very important to distinguish and have clear in mind the difference between those two terms, dissemination and communication. And also, when we talk about exploitation, we're using actually a synonym of use of the word to use, and not really, it doesn't really have a bad or a negative meaning like it might have, for example, the exploitation of the rainforest. So they are English words, but I would say a lot of them have their own meaning within this particular field that we are going to describe in the next few slides. And therefore, let's take a couple of description and definition of these words, like background and results in this case. So background is actually what we bring inside our project. It is tangible or intangible input. Is data, know-how, or information which is held by the project partner before they access to the grant agreement. It might be IPR, copyright, patents, or patent application, whatever. The point is that this background is brought within the project and remains property of the parties that bring them into the project. However, it has to be written down in writing, and there is a part of the consortium agreement where you can write down this background, which is normally the attachment 1, and in which all parties should specify what kind of information they are excuse me, bringing into
the project. It's true, the background is yours and remains yours. However, if you are bringing it within the project, it means that you need to share it anyway. So provide access to others to that background in order for the project to be developed. Because otherwise, if the background of the parties could not be used by other parties in the project, we wouldn't have a collaborative research environment, and we wouldn't be able then to carry out the activities that have been promised in the description of the action. The activities are there in order to reach a point in which we can present the results to the European Commission. The results are the output of the project, and if you think about it, results are a synonym of intellectual property. They are a product of the mind that might or might not be protected, but that is a intangible assets, because with our hands we cannot really touch our results. We might touch the papers in which the data is written, for example, but the idea itself is something that is untouchable. So results are generated within the project. They might or might not be protected, but they are our final goal that can be reached, or that should be reached, throughout the project activities. Access rights are a very important thematic within Horizon 2020 funded project. Access rights might be to results or might be to background for project partners. Access rights to results are the right for the parties to have access to results that are generated by other parties throughout the action, or to background that is brought by other party throughout the action. There are different conditions for access rights, and we're going to see them in the next few slides. Also, exploitation activities. As I told you, exploitation is a synonym of use, utilization of the results, and it doesn't have any form of negative meaning that in English also this word might take, or yes. Therefore, exploitation is use, and the European Commission is telling us that results have to be used from a project. That might be further research on those results, it might be commercialization, it might be whatever action that brings actually to the utilization of the results themselves. And dissemination, and please do not confuse it with communication. Dissemination means to public disclosing project results to certain targets that might be interested into the use, so the exploitation of the results themselves. So when we talk about dissemination, we absolutely always talk about results, because results are the object always of the dissemination activities. Instead, when we talk about communication, we might also be talking about other project activities, project composition, project structure, and so on and so forth. And it doesn't necessarily have to do with project results, but communication is simply the talking about the project outside the project environment without really mentioning the results to a public that might be interested in the use of the results. From the grant agreement, we also received some very important rules regarding ownership. A general rule of a grant agreement in Horizon 2020 and also in Horizon Europe is that the results that are generated through the project belong to the participants that has been generating them. I told you before that the rules in the grant agreement are the constitutional rule of the project, because they cannot be contradicted by any other rule within the project life cycle. But I also told you that those rules are very general, and that is a blunt example of that. Think about it. We have the rule is very simple. It's very easy to understand. Of course, the results belong to the partner that has been generating them. However, we are in a collaborative research environment. We have different parties that are collaborating in the generation of the results themselves, and sometimes it is very hard to determine which is which. So who has generated certain results and who has not taken part to that particular work that led to the results to be created. So that is why those rules, it's true, are the basis of our cooperation, but they need to be more specific, and we can specify them through the consortium agreement. And if we take appropriate measures to manage such ownership issues that might arise by the collaboration activities and the rules of ownership, then we can have a better also relationship within the consortium and clearer rules regarding ownership, and maybe a easier exploitation of the results generated. So this was just to make an example of, first of all, one rule that is coming down from the grant agreement, and secondly, the rule that can be steered, not contradicted, but steered within the consortium agreement and modified to the advantage of the exploitation activities within the consortium. Another contract connected to that is the joint ownership agreement. Sometimes we can find it directly in the consortium agreement. Sometimes instead we can find it separated from the consortium agreement as soon as the results are going to be generated. Why do we often have joint ownership agreement? Because, as I told you, the rules of the grant agreement are very general. They say only the results belong to the participants generating them. But we might have 19, 20, 25, 30 participants, and for example, one of them has put their background in it, therefore they participated to the generation of the results. The other one have a lot of person per month involved in the work, and therefore they participated as well in the generation of the results. Another one coordinated all the work among the parties and contributed to the exchange of document, for example. That is also a form of participation in the generation of the project. So all these three parties are parties that actually actively participated to the generation of the results, and therefore theoretically have a share of ownership. Now, the parties may agree to limit or exclude, for example, their share of ownership on the results and allow one single party to be able to use the results for the exploitation activities, or license out those results to this party exclusively so that they can exploit the results in the market. So there are many ways and forms of so to say walk around the rules of the grant agreement at the advantage of the exploitation activities within the consortium. One thing that sometimes is scary for all institutions taking part to the project is the access rights to the results and to the background. This rule, also coming down from the grant agreement, says that parties need to provide access rights to their background and to their results, as long as other parties within the consortium need them to provide project-related activities, or also to carry out exploitation activities. And sometimes the consortium agreement might be tricky because the access rights have to be granted. So that means that if you've got something in your background that I talked to you about before, you cannot refuse to give it to a party within your consortium for the whole duration of the project plus 1 year after the project has ended. Why am I saying that sometimes this is tricky? Because this 1 year very often is brought to 2, 3, 4, 5 years as well in the consortium agreement. So it is always important to check whether this time lapse has been changed within your consortium agreement, because otherwise we've had some cases in which some institutions have found themselves in the unpleasant situation of having to grant access rights for a long time after the project was ended and after they were receiving the funding provided for the project. So pay attention as well if you're creating a consortium agreement, or if you're discussing about access right with other parties with regard to these rules. I told you access rights have to be granted. The difference between the grant of access rights is in the use that you need to do with them. If you use them, if you need them for project implementation, either that we're talking about background or results, they have to be granted royalty free. Instead, if we are use them for exploitation activities, they have to be granted on fair and reasonable conditions, which means at a certain fee that is determined by the market, more or less. So those are the general knowledge, the basic knowledge. I would also say that is necessary to know when we are talking about intellectual property in European funded projects, and also I think are important in order not to make mistakes, basic mistakes, I would say, when we are writing down the proposal. In the next part, so the intellectual property in the project life cycle, we go a little bit into some thematics that are more sophisticated, I would say, in the sense that they give a couple of example and best practices with regard to projects, to intellectual property management within the projects. There are expectations on intellectual property management, and we cannot lie regarding this. When an evaluator is actually reading your proposal, depending on the technology readiness level that you are at the beginning of the project and you want to be at the end of the project, he or she is going to have expectation on the exploitation part of your proposal, and on the strategy that you're going to use in order to exploit the results. And of course, not every project might have the same exploitation strategy. Because a project with a low technology readiness level, for example, will not have the same intellectual property, and therefore intellectual property rights produced by a project that is actually very near to the market. So it is necessary, especially in the proposal, and therefore during the project life cycle, once the proposal has been founded, to take into consideration the point at where we are and the point in which we want to arrive. Otherwise, a general description of the exploitation part of our project is not going to be helpful for the project. It's for the evaluation of the project. So good ideas are, when we are writing the proposal, first of all, to define the state of the art. I was telling you the point in which we're going to start, what TRL we have at the beginning. Find the state of the art, what has already been done, and how are we going to go through this bar. So are we going to raise the bar with our project? And you can do that, for example, by searching in patent databases like eSpaceNet or other useful documents. Why? Because patent databases are actually a very, very large source of knowledge. And they are for free. Everything you can find on SpaceNet is completely free. So if you can find, for example, a patent that is describing the state of the art that you are going to use, that you are going to improve, for example, throughout your project, you can analyze this patent as well and say whether perhaps you plan, in order to exploit the results, to take a license out of that patent in order to be able to use the technology, or even better, if that patent has already expired, for example. Also, technical drawings are within the patent itself, and also we provide, as European IP Helpdesk, some confidentiality agreements that are mainly to be used for external experts that collaborate within the project, but it might be mentioned in the proposal, for example, that a peculiar eye on confidentiality is going to be kept. And there is going to be, of course, a important phase within the proposal writing, so before the projects start, that is going to be drawing a convincing outline of the exploitation strategy at an individual and a consortium level. And that is going to be in the impact part of the proposal. It might be that for more complex project, even a specific body for intellectual property management is going to be necessary, and therefore certain people have to be appointed in order to, for example, identify the most important results that are going to be exploited and how to protect them and use them. In any case, the central document for that is going to be the PEDR, the Plan for Exploitation and Dissemination of Results, which is a living document in the sense that you're going to write a first draft at the beginning of the project, during the project, the proposal writing, but you will have to update that plan throughout the whole project duration. And that means that you will also have to communicate to the Commission, or to let understand the evaluators throughout the project, the proposal writing, that you have already planned time and energy for the update and the steering of the plan for exploitation and the dissemination of results, and not that you're simply writing one at the beginning of the project, then you're putting that into the drawer and you're not using it anymore for the whole project duration. That is a very, very good way to lose points in the impact part of your proposal, because in that way you are actually showing that you do not have plan for exploitation and dissemination of project results. Excuse me. There we go. There is an obligation also coming down from the grant agreement to define the expected results and the strategy for exploitation. And that, I told you, is going to be done in the Plan for Exploitation and Dissemination of Results. We have a dedicated, by the European IP Helpdesk, fact sheet on this document for Horizon 2020. We are developing one also for Horizon Europe, but it's going to take a little time in order to be able to come out with this. But the main points that should be taken into consideration at every phase of the project, both at the creation of the Plan for Exploitation and Dissemination of Results, and then also throughout the project duration, are the description, the ownership status of the results, the sector of application, the protection measures that can be applied on the results. So what kind of results, of course, are going to be generated, and why are they relevant for exploitation activities? The ownership status is what I have been telling you before. Who is going to own the results? And that is relevant because if, for example, in one consortium, the consortium can agree that one partner only is going to own the results, that means that this partner only actually is going to be able to exploit those results, and that might have some sort of advantages of a certain monopoly within the market. And the protection measures, of course, are naturally connected to that, because if you have a patent and there is only one partner of the consortium that is going to be able to exploit that technology in that patent, is certainly going to have great advantages within the market. All these points, all these peculiarities have to be raised in front of the evaluator within the proposal in order to be able to bring his attention on the fact that you have been thinking about all these facts when you were writing the proposal. During the project implementation, now that is something we need to say before that, because you can try to imagine all the results that are going to come up in the project duration while you're writing the proposal. You can try and foresee what is going to be created and how valuable that is going to be, but you are actually going to realize which are the really key exploitable results and how important they are only when you will have them generated before your hands. So that is the reason why the plan that you have at the beginning can change, and the management and the protection of the results can also change throughout the project, and some relevant factors have to be monitored, like existing publications, patents, or other markets, and competing technologies and standards, and so on and so forth, because all these issues might modify the plan that you've had at the beginning of a project and that you're actually having now in the middle of the project or towards the end of a project. For example, if you wrote down in the plan for exploitation and dissemination at the beginning of a project that you were going to patent your results, but then you find a publication that was not published by you, that is actually describing a large part of the results that you have generated, or something very similar, which is then reducing the scope of your potential patent, you need to think about something else, because the patent is not going to be granted on something that is not new. And given that somebody else has already published part or something very similar to what you're going to be generating throughout your project, then that is not a patent protection is not a viable form of protection anymore. And then as a consequence, also exploitation activities that, for example, were based or would be based on license or assignment of the results are also not viable anymore. This is just to give you a short example on how you will need to be flexible throughout the project duration, and on how the events that of course happen throughout the project itself might influence also the plan for the exploitation. That is not, and I say it again, written in stone, but can be changed throughout the project. We're going to talk about, once again, because it's probably the most central term part of the presentation of the joint ownership. I told you the rules for the default regime that we have in the GA, the grant agreement. The results belong to the participants that have been generating them. I told you sometimes we have 19, 20 partners generating the results all together. So they have a joint ownership of the results. What we see and usually do within project is that we agree on a tailored joint ownership within the consortium agreement, meaning that we write down that the results, a joint ownership agreement is going to be concluded among the parties as soon as the results are going to be generated. Meanwhile, parties are free to use the results, for example, if they provide a prior notice of 45 days to the other parties of the consortium. So think about also the matter of joint ownership within the proposal, and think about how to convince the evaluators as well that the proposal is going to take care of ownership issues and that they are not going to create problems or issues among the parties. Why that? Because if there are discussions on the ownership, normally there are connected also delays in the exploitation of the result. That is something that always happens. And given that, so to say, time is money and the money is paid by the founder, the European Commission, what they absolutely would like to avoid is that exploitation cannot start because of internal fights within the consortium, especially connected to matters of ownership. There might be rules within the consortium agreement that ease or make a little bit stricter the use of the results. I told you already, actually, this point that there is a general possibility to use the results if it's communicated 45 days in advance, or simply that parties are allowed to use the results without any form of restriction. If you use the DESCA model, that is going to be either option 1 or option 2 of the model itself. It has to be said, at least in our experience, that research institutions are quite have a little bit of uneasiness in accepting the fact that other companies or institutions are freely able to use the results even without a joint ownership agreement. However, sometimes that might happen. In case you will find yourself seeing somebody writing down a joint ownership agreement or writing it down by yourself, those are a couple of points that should be inserted into the agreement itself. So the identification of the joint owners, allocation of shares. So it's true, we are all joint owners. That is what I told you before. I am a joint owner because I have put a lot of person per month in the project, and a lot of investment in terms of time and money. I have put a lot of background in the project, so I am a joint owner as well. I have facilitated the communication among the parties, so I have contributed, and I am a joint owner as well. That's fine. and everybody has a right to be considered the owner of the results, but how much? That's also another important question that is not solved by the European Commission in the grant agreement, and that we can allocate of share allocation, we can solve through share allocation in the joint ownership agreement. The condition for the commercial and non-commercial use of the jointly owned IP is a very important issue, because, for example, some institutions, especially research institutions, might be interested only in non-commercial use and not even in the ownership itself. So it might be that one party, for example, retain the all ownership of the results, while another party is simply then using the results for non-commercial use, and so on and so forth. I left a couple of other points, but they go a little bit even more in detail, and I would just leave it for your knowledge in the slides. I will go through in the last part of the presentation other three very important rules that are given us by the European Commission in the grant agreement, which are the general obligation to protect, the general obligation to exploit, and the general obligation to disseminate. General obligation to protect says that within the project we have to examine the possibility of protecting the results, and whenever it is reasonably expected to exploit the results, or the protection is possible, reasonable, and justified, we should then protect the results. And that is something that should be clear also in the proposal writing phase, because we cannot simply say generally we are going to protect all results that are going to be generated by the project. First of all, because not all results are protectable, sometimes protection is not possible. And secondly, as I can show you here, because some form of intellectual property, so results generated, are not protectable through a particular intellectual property right. So some intellectual property rights are applicable to some results, but not to others. So the best way to persuade the evaluator that we have no clue about protection activities is to say that all results are going to be protected, whatever their nature and whatever their status. That is wrong, and if possible, we should try already in the proposal to be as specific as we can, in order to make the reader and the evaluator understand that the plan that we have in order to exploit the result is as specific and thorough as possible. Secondly, we have the general obligation to disseminate, which means that as soon as results are going to be generated, they have to be handed out to the public, to the general public, to the scientific community or broader public, depending on whom could be interested in such results. But it's important, in order to not to break the rules for protection, that before we disseminate the results, actually we check whether a protection is possible, because in many cases, if we have already published, for example, our paper, and some form of interesting information are there that are also part of an invention that could be patentable, the fact that we published our paper is going to make our invention not patentable anymore, because it's not new and therefore not patentable. So we have normally in the consortium agreement, and that is something important for every member of the consortium, a dissemination checklist that says that before we can disseminate the results generated, we need to communicate that 45 days in advance to the other parties of the consortium. And that is very important because that is valid for the very long paper that is showing interesting and important information regarding whatever topic, but that is also valid for the poster that is brought to a conference, for example. So it has to do with all researchers involved in the action and not just with the institutions themselves, because even that poster that is showing some drawings, for example, of the invention that might be patented could be novelty breaking and therefore prevent the consortium from patenting a certain invention, and therefore prevent the consortium from having the chance to carry out certain exploitation activities that without patents, for example licensing again, or assigning, are not possible anymore. A couple of words on open data, since we are talking about dissemination. So as you may already know, the Horizon 2020 project were characterized by the fact that all information had to be provided open access, and we're talking about publication as well as data. So it has to be provided online, free of charge, to the readers or to any interested users. Horizon Europe is actually going to be the same. There is going to be an obligation to ensure open access to all peer-reviewed scientific publication related to the results of a project and participation in open research data. So everything actually that you are going to study within a project has to be made available for free and online. And therefore, many questions that we receive are, how is that possible that at the same time I have to protect my results and make them available anyway? Well, because that it's possible actually if you simply ensure that the obligation to protect is taken care of before the obligation to disseminate. So you can disseminate and you can leave information for free to everyone for knowledge, of course, as much as you want, and you can still have them protected, meaning that, for example, a patent that is registered and then published is still published online, meaning that the information that are within the patent are available for the whole community. But still, there is a form of protection in that the owner can exclude the use of his patent or prevent somebody else from using his patent in the market. So they can prevent the use, although the knowledge is shared anyway. And that is exactly the point that the Commission here is trying to bring the message to us, that we can have protection and at the same time, in fact, protection is simply influencing the use of the results and not the fact that they are actually available for the whole community. If you want to know a little bit more about open access, so green open access, gold open access, and the different forms that are there for use, you can check out perhaps our fact sheet that you can see here attached in the links in these slides. One last information regarding the protection and the dissemination is that those are all eligible costs, meaning that, for example, if you want to file a patent, all the costs that are connected to the filing of that patent are going to be reimbursed to you by the project and therefore by the European Commission. I will speed up with the final part of the general obligation to exploit, because we come to an end of the presentation, and this is another rule coming down from the grant agreement that says that you need to use the results up to 4 years after the project is completed. And but please pay attention that exploitation, of course, means use. I'm telling you again. But it does not mean monetization. It does not mean economic use of the results of the project. It can also very well be using the results for further research activities outside the action. So if you plan to use further refine the results after the project has ended, that is perfectly in line with the definition of exploitation. You only need to check that that is in line with the technology readiness level you have, because if you come up with a very interesting invention that could be very well already be put into the market, and you write down that your exploitation activities are going to be further research afterwards, then you're going to very much disappoint the evaluators, and that is something you should really try to avoid. The exploitation strategy that might be set up throughout the project duration, I told you, is changing from the sort of intellectual property right and intellectual property that you have generated, the technology readiness level of the project, and therefore all these elements might be influencing the way you should write down the exploitation strategy for the evaluators. And you should then perhaps take these slides and see what kind of consequences, changes connected to one of those 5 points might have on the plan for exploitation that you're going to be carrying out. Also, there are other obstacles that should be taken into consideration, of course, depending on the project, with regard to the landscape in which, for example, you would be operating. That might be a market, but also a research landscape. If there are, for example, existing intellectual property rights that might block you in the commercialization of the products, other regulations that might be of that might be of obstacle for the creation of the results, or that might put you into more difficulties. For example, I'm just on the top of my tongue, the fact that in many states embryonal research or with human embryons, it's not allowed. In other states, yes, and so on and so forth. There might be other market issues. So also these points you can see here in the landscape should as well be taken into consideration. And if you find some forms of obstacles that might be there and that could prevent you from reaching the objective of the exploitation, perhaps they should be analyzed in detail, and it should be explained to the evaluators how you plan to overcome these points. There are different routes for exploitation. I was telling you before, the selling of IP rights, the licensing of the IP rights, they are very interesting because in case of mistakes, like the one that I was explaining to you before with the publication, and that brings to the lack of patent or intellectual property rights, then those two ways of exploiting, like the selling and the licensing, are not available anymore. And therefore it might be, and we go back to the plan for exploitation and dissemination of project results, that the plan that you had at the beginning of the project cannot be the very same plan that you have in the middle of the project or at the end of the project, and you actually need to change something in there because selling or licensing is not available anymore because it was a mistake, but still we need to face the consequences of the mistake and so on. Excuse me. So just to summarize a couple of information at the end of the presentation, we need to take into consideration the intellectual property that is used through the project, and there we saw the background. What is background and how to use the rights throughout the project duration. What is going to be the intellectual property generated by the project, so the results, but it's very important to see also who's going to own such results in order to have clear in mind who will have the chance to exploit them, how are we going to manage them within the project. Is there going to be the need for a dedicated team, or is the output still quite small, and therefore the whole team can take care of that without having a specific cell completely dedicated to that. Here I wrote secure evidence of creation per pre-publication review and technical invention. Why? Because I told you the rules on ownership by the European Commissions are very general, and therefore having a form of showing also to the other parties the way that you have contributed to the creation of the results can provide you with a way of having access to a share of the ownership as well. The assessment for the exploitation activities: what is the prior art, what is the market all around us, what are also the difficulties connected to that market, what are the obstacles for the creation of the results as well. And we talked about the general obligation to protect through patents, copyright, so that whenever, however, that is possible. And the fact that you need to be as specific as possible when you're saying that you're going to protect some form of results, because if you don't, then you're actually making steps in the wrong direction instead of the right one. And the other two obligations is that general obligation to disseminate and exploit, so the use of the results. And we have a little bit seen how to use such results. So this is I would say, a tentative of bringing everything together to what I have been talked about before starting a couple of minutes of questions and answers. I had a couple of slides more, but I think we can actually stop here. And yeah, I'd like to thank you for the attention, and I'm actually open to question if you'd like to ask some questions. Thank you very, very much for being here. It was a pleasure for me to assist you, so to say, with regard to intellectual property rights. And if you have further questions after the session that you would like to ask, the helpline, as I told you, is always there. to support you, but not in the way that Faima was asking, in the sense that writing the proposal and so on, but to clarify some sort of thematic and issue that might be of advantage for you in the moment in which you're writing the proposal, but they're not going to write or correct the proposal for you. I can wait very gladly for the questions. In the meanwhile, I thank you very much, Jenny, for making this webinar actually possible. It was a pleasure for us to put at use our webinar platform, and you found a lot of participants, which was for us really a very good win-to-win situation. So thank you very, very much once again.
Yeah, thank you very much, Michelle, from all of us here at EURAXESS ASEAN, and to all of you who attended too. So I'm sure the others are also waiting for the slides and the presentation as they become available. But I mean, I was going through the presentation myself, and it's really a wealth of information. And I think, you know, this issue on open access is something that is a big question here in ASEAN. And so I'm sure, yeah, maybe we can have a follow-up on that soon, but I'll email you regarding that. But for the meantime, thank you so much to you and your team.
Thanks to you. I will send them the fact sheets on the open access rules, or perhaps we can talk about it a little bit now if you want to.
Yeah, I mean, I think we can have a, you know, a talk about it as another one.
Yes.
Another.
So
we want to invite you again. So, yeah.
No, I
so
think I lost you. I didn't understand. Do we want to talk about it now or another time? I'm sorry.
no, another time. I think we can
time.
have.
Okay. Perfect. No, gladly. It's actually a very important issues at all level of research, because it's a interdisciplinary rule that takes pretty much all outputs, all results. And so everything that you're going to produce within a project has to deal with the open access rules set down by the European Commission. There was a pilot before that gave you the chance whether to choose to follow that rules or not. Now there isn't anymore. So yes, we can get in touch and make something about that very, very soon with pleasure.
Wonderful. And I don't see any question inside. So,
but if they pop out, as I told you, you can simply write them and we will send them to the helpline.
Okay.
All right. It was a pleasure for me. And I wish you all a very lovely day, and stay healthy, of course, in those times.
Bye, everyone. Thank you so much.
Goodbye.